All right, so 5 ways to fund your living trust. You finally got your living trust in place, but your assets are still in your personal name. And if you're in California, that one mistake could force your family into probate court, costing them months of time in probate court and a lot of money in probate and attorney fees. So today, I'm going to show you exactly how to fund your trust properly, step by step, so the plan you made actually works when it matters most. Look, I get this question almost daily in my practice. And the question is, I have a living trust, but how do I actually put my assets into it? And I understand why this confuses people. Creating a trust document is really just the first step. I'm Ali Talai, trust and asset protection attorney, and also founder of Talai Law Offices. If you don't properly fund your trust, it's like buying a safe, but leaving all your valuable assets sitting on your kitchen table. The trust cannot protect what it doesn't own. In California, assets that aren't properly transferred to your trust remain in your individual name, and that can trigger probate if the total value is over California's small estate limit. In other words, you could end up in the exact same situation you were trying to avoid when you created the trust in the first place. Today, I'm going to walk you through 5 specific ways to properly fund your living trust using real examples from my practice and the legal requirements in California. By the end of this video, what I'm hoping is that you will know exactly what steps to take to make sure your trust actually works the way it is supposed to do. All right, so let's talk about transferring real estate through proper deed recording. One of the most common and most misunderstood steps in funding your trust is transferring your real estate into it. I see more mistakes here than almost anywhere else. You cannot just list your property address in your trust, in the back of the trust, and then assume that is all you need to do and that would fully cover the transfer of the property in your trust. That is incorrect. In California, real property must be transferred with properly prepared deed. Here's how it works. You need to prepare a new deed that shows the property being transferred from you as the current owner to you again as the trustee of your trust. The deed must include the full legal name of the trust, the date your trust was originally established, not the date you're signing the trust or the date of any amendments or restatement that you might have done to your trust. The date that you created the trust is the date that goes on the deed. Now, technically, that deed that we just talked about you creating and having the right name, the right date, and all that stuff on it doesn't have to be recorded to be legally a valid deed, but recording it is absolutely essential. If the deed isn't recorded, third parties like title companies, escrow companies, or even the probate court may not recognize the trust ownership. And that could lead to costly delays, title issue, or even probate issue. So yes, California doesn't require you to record a deed for it to be a valid deed or a valid transfer, but in practical aspect of doing these sort of things, you got to make sure the deed is also recorded. Recording isn't what makes the deed a valid deed, but it is what makes the transfer clear, enforceable in practice, and hard to challenge later. In California, real property can end up in probate if it hasn't been properly transferred into a trust. It doesn't matter that the trust document names or shows the address of the property. That is not enough. I had a client whose father had passed away. The father was thinking, I'm assuming, or the children were thinking that the property is in the trust because the trust had the address of the property. But when we checked the county, there were never a deed recorded that transferred the ownership of the property from the dad's name to the name of the trust. And since the property was still under his, the client's dad's name at the time he had passed away, we had to go to probate to get the property transferred from his individual name to the name of the trust. And so, the whole intention of setting up the trust was to avoid probate. But as you could see, that didn't exactly happen in that particular scenario. The type of deed you use also matters greatly. In most cases, a grant deed is preferred option when transferring real estate into a trust, though in some situation you could use a quitclaim deed. But here's what many people miss. If the deed or the accompanying documents like the preliminary change of ownership report is not prepared and filed correctly, the county assessor may treat it as a change in ownership and trigger a property tax reassessment. That could mean significantly higher annual property taxes going forward. And that's definitely not something that we would want to do or achieve. The whole idea is to do estate planning and get rid of some of the issues and concerns that come up when you don't have it. We don't want to create other problems. However, luckily, when you do make these transfers, there are exemptions that can be used so that the transfer doesn't cause a reassessment of property taxes. This is why the deed should be prepared by someone who understands both California real estate laws and also understands property tax exclusion laws, especially if you're relying on a parent-child exclusion or other exemptions. Small mistakes in how the deed is worded or how the documents are submitted can have big, expensive consequences. All right, so let's talk about retitling accounts and financial bank accounts. Bank accounts are usually the easiest assets to transfer, but they require direct action with each financial institution. You cannot just decide your checking account is now owned by the trust. You need to contact each bank and formally retitle the account, or at a minimum, you have to name the trust as the paid-on-death beneficiary on the account. Most banks have their own forms for this process. You will typically need to provide a certification of the trust, which shows the trust name, the date the trust was created, and it allows and it shows you having the authority to act as the trustee of the trust, and also proves that the trust actually exists. The account ownership should change from your individual name to something like John Smith, trustee of the Smith Family Trust, dated January 15, 2024. The tax identification number can usually remain your social security number, since a revocable trust are grantor trust. Here's a mistake I see often. Unfortunately, people assume that naming their trust as the beneficiary on a bank account is the same as transferring ownership of that particular account to the trust. It's not. While naming the trust as the paid-on-death beneficiary of that account will avoid probate if something happens and you've passed away, it doesn't actually change the ownership during your lifetime. The ownership of the account is still under your particular name. So what that means is that something happens to you, you become incapacitated, mental incapacity, and now your successor trustee is in place. He or she will not be able to access or manage the account if you become incapacitated. So to ensure that the trust works as intended for both incapacity planning and distribution, you need to formally change the ownership of the account into the trust name, or you got to make sure you also have a financial power of attorney in your estate planning documents that names the same successor trustee, so that the successor trustee could utilize that financial power of attorney to be able to gain access to the bank account. Investment accounts work similarly, but they can be a little bit more complex. Each brokerage firm usually has its own procedures. Some require you to close an existing account and open up a new one in the trust name if you want to retitle the account. Others can retitle existing accounts. Either way, you will need to work directly with the brokerage firm to make sure the transfer is handled correctly. We can transfer your real estate. We can prepare the deed as the attorney for our clients and make the transfers. With bank accounts, investment accounts, these are not the type of accounts that we personally can do for you. Not that we don't want to help our client. The reality of it is that the institution would not allow a third party. It doesn't matter that I'm your attorney. It won't allow a third party to go in there and make any changes within the trust. So it becomes especially an important step that you have to make sure sure you do after the trust is set up. And again, I've mentioned this before, we could do a fantastic trust, but if the trust or if your assets are not transferred into it or tied into it, something happens to you, you become mentally incapacitated or you pass away, those assets that are not connected to the trust, there's a great chance that there'll have to be some sort of probate proceeding to get them to be transferred into the trust. So it's essential to make sure you fund your trust the right way and you continue to fund your trust as you acquire new properties. All right, so now let's talk about transferring business interests and partnership interests. If you own a business or have a partnership interest, transferring these to your trust requires careful attention to existing agreements and legal structures. This is an area where you definitely want professional help because the wrong approach can trigger unintended tax consequences or actually violate partnership agreements. For sole proprietorship, transferring asset into a trust is usually straightforward, but what's important is that you got to make sure that the ownership of any business-related assets is documented to reflect the trust as the new owner. For corporations, you typically transfer stock certificates, shares to the trust. The corporation's bylaws and sometimes shareholder agreements need to be reviewed to make sure the transfer does not violate any restrictions within the corporations. Limited liability companies present their own challenges. In an LLC, you're transferring your membership interest, but in most cases, the LLC's operating agreement have provisions about transfers to trust. Some require consent from other members of the LLCs, and I've also seen LLC's operating agreement that says if you're going to transfer to your revocable trust, that's all right. You don't need to get consent. Sometimes it said if you transfer it to a trust that you are still the present beneficiary, that's okay. If you're still the trustee of the trust, that's okay. So it becomes super important to make sure you read the operating agreement to see if there are any restrictions or requirements within the operating agreement for the transfer of your membership interest in the LLC to your actual trust. Partnership interest can be the most complex one. Many partnership agreements restricts transfers even to a trust. Some partnerships have right of first refusal clauses that could be triggered by transferring your partnership interest to your trust. In some cases, you might need to get consent from every other partner before making the actual transfer. I had a client who owned a 25% interest in a really successful restaurant locally, and the partnership agreement required unanimous consent for any transfer. So in order for us to transfer the 25% interest to the client's revocable trust, we had to go and get all the partners' consent and have them agree so that our client could transfer the shares, partnership interest to his trust. It took some time, but we finally got it done, and it's essential to make sure that if you have a partnership, that transfer gets done correctly and on time. All right, so let's talk about handling personal property through assignment documents. When it comes to personal property, things like furniture, jewelry, vehicles, and everyday household items, I typically handle the transfer using a general assignment of personal property. This is a simple but important document that formally assigns all of your current personal property along with anything you acquire in the future to your trust. It's broad, catch-all approach that avoids the need to list every single item that you have or anything else that you acquire that could just take a lot of time. For example, most clients don't retitle their cars with the DMV, especially since cars tend to be sold or replaced every few years. Instead, including them in the general assignment is usually sufficient to show your intent to have those assets governed by the terms of your trust. If you own high-value personal property like fine arts, antiques, or significant jewelry, we can include a separate, more detailed assignment to identify those specific items. In some cases, you may also want to obtain an appraisal for insurance purposes or estate tax planning purposes. Now, some personal items that aren't transferred during your lifetime can still be captured by your pour-over will, which is another document as part of your estate planning documents. This is sort of works as a backup plan, as a spare tire, and it allows the assets that are outside of the trust. This pour-over will sort of pours it over into your trust so that they can be governed by the terms of the trust. The one thing with this pour-over will, it doesn't happen automatically, and if we're relying on the pour-over will to transfer an asset into the trust, that means we have to go to probate court, we have to petition the probate court and get a court order that says such and such property are now being transferred into the trust. It's definitely a shorter process than a regular probate, but it's probably not the best option, and that's why it's the last resort. The main idea, the main goal is that after you create your trust, you got to continuously think of making sure how you transfer these assets into the trust and making sure that the assets are actually transferred into the trust or somehow connected to your trust. All right, number 5, last one, coordinate beneficiary designations with trust goals. This last method is different from the others because it doesn't involve transferring current ownership to the trust. Instead, it's about making sure your beneficiary designations on retirement account, 401k, pension plans, life insurance policies, annuity policies, and other assets work together with your trust plan. Retirement accounts like 401ks and IRAs generally should not be transferred directly into your revocable trust during your lifetime, because if you do that, that will trigger unnecessary taxes, and nobody wants to pay taxes, especially if they don't have to pay it. So we never change the ownership. Instead, these accounts are typically coordinated with your estate plan through the beneficiary designation form that the particular account has. You have a few options when it comes to naming beneficiaries. In many cases, individuals like your spouse or children are named directly to preserve income tax advantages available to them. However, you can name your trust as the beneficiary as long as your trust was drafted to include a see-through trust provisions. This will allow the retirement account to be distributed accordingly to the terms of your trust while still preserving tax benefits. The key is making sure your beneficiary choices, whether individual or your trust, are consistent with the rest of the estate plan and supports your long-term goal. Life insurance policies offer more flexibility. You can name your trust as the beneficiary of the life insurance, and this often makes sense when you want the insurance proceeds to be managed according to the terms of the trust. This is especially useful when beneficiaries are minors or you want to have a plan in place that allows ongoing management, and we're doing an asset protection planning for the beneficiaries. The key is coordination. Your trust plan, your beneficiary designation form, and your other estate planning documents need to work together as a unified strategy. For example, I had a client who had done a great job funding their trust, their real estate, their bank accounts, but they had never updated the beneficiary designation form for their life insurance. And the insurance policy still named their adult son as the only beneficiary of the trust, even though their trust plan called for the insurance proceeds to be divided equally amongst their 3 children. So we had to update the beneficiary designation form to name the trust as the beneficiary instead of their one son. And so that at the time the insurance is now paying out the policy, it will flow into the trust and it'll be distributed amongst their 3 children. Funding a living trust in California, as you could see, involves transferring assets, somehow tying the assets into the trust so that we could make sure that it avoids probate and they're properly managed. But as you can see, it is not one size fits all process. Different types of assets require different transfer methods, and the legal requirements vary significantly. The reality of it is, the most important thing to understand is that creating a trust document is only the beginning. The trust can only control and protect assets that are properly transferred or assigned to it. And unfunded trust is essentially worthless when it comes to avoiding probate or providing the other benefits you had created the trust in the first place. This is also not a set and forget it process. You acquire new assets through your life. You need to consider whether they should be transferred to the trust or assigned to the trust. Many people do a great job with the initial funding, but then completely forget when they acquire new assets and they just acquire under their personal name. If you want to make sure you're not missing any of the foundational steps in your estate plan, I'm hosting a free webinar called The 5 Biggest Estate Planning Mistakes and How to Avoid Them. I will walk you through the most common traps I see, mistakes that can cause probate and trigger unnecessary taxes or leave your family in a legal mess. It's free to attend, but you do need to register to save your spot. And to do that, you can visit our website, talailaw.com, or you can just click in the link in the description. If this video was helpful, do me a favor, hit like, subscribe, drop a comment if you have questions. Now, funding your trust properly is definitely essential, but it is only part of a complete asset protection strategy. Even with a properly funded trust, there are still ways that creditors and attorneys can reach your assets if you don't structure your estate plan correctly. That is exactly what I'm going to cover in my next video, how to stop an attorney from suing you through your LLC. I will show you the specific legal vulnerabilities that most business owners don't even know it exists and the strategies we use to close those gaps before they become problems. If you're serious about protecting what you have built, you need to understand these concepts before you face a legal challenge. If someone files a lawsuit, your options become much more limited, unfortunately. So I look forward to seeing you over there.